Well, another fantastic presentation. So comments, Aldo, I guess she has big fantasy.
Yeah. Stronger use of animations now.
Yeah.
So it's very pleasant to see.
Yeah, it was fantastic. It was really fantastic.
Thank you.
And Alex, any comments?
It's good. The only thing I guess is I wouldn't put the entire text of the law on the slideshows. You can't read it.
Yeah, you're right.
Just summarize it.
Summarize it, or else put the text, and then in the next one say these are the 3 or 4 points that are necessary in case somebody can do it. Yeah, no, that's a good point.
It's really good.
That's a good point. Yeah, and very clear. I like and I know June's going to cover this, but I like the discussion on the well-known mark with the Pizza Hut case, because a lot of people don't understand that was the first case. I think it was in '87, you said?
Yes, in 1987.
And that was even before the idea of well-known marks even they wrote up.
It is the first well-known mark established by the China Trademark Office.
Oh, is that right?
When it's accession to the Paris Convention.
Oh, okay. And then I thought it was what's the name of that medicine? It's called
Tonentang.
I thought that Tonentang I thought was the first one. I know in Japan they had it's a long story, but we'll wait for June's presentation. I guess we'll cover all that. And I also like that Harvard was founded in what year was that?
1639.
Well, just a few years before I was born. Right, and actually, interestingly enough, Harvard is a guy's name. The founder was a guy called John Harvard. That was his real name, his surname. I don't know. I never heard another Harvard before or after that. But good. Any other comments, questions there?
Daisy, please.
Daisy, Miss Daisy.
I'm really interested in trademark. So I want to know whether there is a standard about well-known trademark. I know there is a standard in according to trademark law, but I think it's very abstract. So can you give us an update about the standard? How to describe well-known trademark?
For this question,
I will tell you later.
Yeah. That's a really tough
as
question.
you know, in Chinese trademark law, in Article 13, I remember, it has the standard about the well-known mark, maybe like the long-time promotion, long-time registration, and how do you say?
Good reputation.
Good reputation among many countries, and
also among the Chinese citizens.
Also among Chinese citizens, it's most important for the recognition in China.
So give a few examples, Cherry, of some well-known marks.
For the well-known mark.
Under IKEA was one.
Because, such as one of the trademark or P&G, Procter and Gamble, that is a safeguard for the soap.
Wow. I had no idea. But I was in the shower using this.
It was recognized as a well-known mark in China. Also, there the opposition case by the Trademark Office, and other trademarks like Apple Computers logo, that Apple logo, and Apple in both Chinese mark and English word. All they are the well-known trademark.
Right. Jerry, you were saying one?
No, Epson.
Epson is one?
Yeah, sure. In last year.
Oh, okay. Good. No. Yeah, there's got to be a lot of them. I'm sure. Grace, you know some good? June better know some next week. Right. Well known ones. Yeah.
The only Italian.
Which one?
Ferrari.
Ferrari. Our Italian friends are piping in there. Everything's about Italy. We're always getting on Ferrari. Okay, good to know. Any other questions, comments, criticism? Yes, Sherry.
So
yes,
I have
Sherry.
2 questions.
Go ahead. I know. See what happens.
First of all, what's the difference when we say logo and trademark? Is there any difference?
Yeah, good question.
Actually, no different. But trademark is in our attorneys also say trademark, but for the clients they also call it logo. Actually, no difference.
No difference yet, but like because right, I think trademark, was that a term of art? I mean, which means it means something very specific, and I mean logo, I guess, is describe a lot of stuff, I guess, more stuff. I mean, but trademark would be I guess, the proper term. And that logo is what? It's called a device, right?
Mm-hmm.
It's called, so, I mean, I guess the part of the, or maybe I'm wrong, so don't, tell me if I'm wrong.
It's the opposite.
Sorry.
Like logo is the most graphic element. Instead, a trademark can be also a word without no graphics. Like you can register and
even I'm wrong, Mr. Expert in Trademark.
I don't know the name in English. Nominative trademark. Denominative trademark. So you
okay.
register only the word without any graphic, without a shape,
So
just the word.
Word is a
And
trademark.
then maybe you register also a graphic trademark
Mm-hmm.
of this word.
Yes,
So-
and because trademark could include the logo, the Chinese characters or other Latin words, but logo is mainly concentrated on the device. But for the clients, they also call their mark logo or
Yeah.
yes. But we also call it device. That is the difference. This morning I discussed with Grace because we call it device, but the client may call it logo. Actually, they are the same matter, I think.
So I had it backwards, right? Did I, Grace? I think I did. Did I explain it backwards? Which is okay. I don't want to confuse anybody. So I'm written up as a so-called expert in trademark, so if I get it backwards, be careful. No, that's a good one. Okay, question number. Did that answer your question, Sherry?
Yes.
Okay. Number 2. Sherry to Cherry.
For the case Harvard,
Harvard.
now that the Harvard and the Harvard Chinese and the applications so similar, why now the CTO reject it? And does the
Rejected it in the
CTO
first place.
yeah, has the right to reject it when the trademark apply?
Excuse me, pardon.
Yeah, no, it's why Sherry, I guess, is saying, when you put in Ha-Fu, right, why the heck did they even allow it in there? They shouldn't have even allowed it in. And your answer is?
Because anyone could apply for the application, and as introduced by Jin-3 just now, the trademark examination procedure may contain 2 steps. For the formality examination, and the other step is for the substantial examination. I guess that this month, Harvard was rejected during the substantial examination, since everyone could apply for any logo or Chinese characters or Latin words with the Chinese Trademark Office. We all have this right, but the examiner will examine such mark during the examination about this mark. So, as you have asked the question, why the examiner has not rejected this mark when it fell in the office, right?
I think that's the question. I mean, so they have like an intake department, and then there's a review department, and the guys review it, and they say, this looks bad. This is a possibility, and we're going to reject it. That's what that substantive review means. Somebody looks at it. Some stuff doesn't have substantive review. What doesn't have substantive review? Anybody know? Not in trademarks. In another area, no substantive review is design and utility patents, right? Everybody knows that. Okay, good. No, very nice explanation. Does that satisfy your curiosity? Okay, great. Anything else, Grace? Any other? I think your team did a great job. Fantastic job. Jerry, you okay with it? You're okay. Joan, any comments? No? Kelly? Kelly's such a good presenter. It's always good. Mike, anything? Okay, fantastic. Okay, thanks everybody for attending, and we will see you next time.